Hello everyone, this is Nadine from ChemLinked. Thank you for joining our webinar. Today I will talk about China's new draft regulation on chemical environmental risk assessment and control. The regulation is under public consultation and our company has received some industry feedbacks. And we are sure there are more people interested in it, so we host this webinar. Come back to today's webinar. Let's look at the main contents. First of all, I'd like to introduce the background. Then I will spend some time going through the regulation details, including China's environmental risk assessment and control plans, and the future new chemical management. Now, let's go into details. Starting from the background. Some countries and regions enact REACH-like chemical program, like South Korea, Turkey, Taiwan, while the Canada, Japan, the United States, and Australia's chemical management program is quite different. It has been years we are talking about to have a real China REACH in China. Although China was initially looking to develop a REACH-like regulation, considering the administrative capacity and the burdens from a REACH-like regulation. Finally, we see this new regulation drafted by China MEE, named as the Regulation on Environmental Risk Assessment and Control of Chemical Substances. For China, the regulation is recognized as a more workable and more favorable alternative to the burdensome REACH-like programs introduced by others. This is the regulatory framework of China's laws and regulations. The draft regulation we will talk about today is in the second tier. Above it is the Environmental Protection Law. The regulations are formulated and promulgated by State Council, such as the Decree 591, which I think you are most familiar with. It is the regulation on control over safety of hazardous chemicals. So the draft regulation we are talking about today, if promulgated, will be at the same administrative level as Decree 591 and will make up the limitations in regulation of environmental management of existing and new chemicals. Overarching laws and regulations shapes the regulatory landscape, and more detailed requirements and rules are formulated by ministries. For example, the MEP Order 7, the measures for the environmental management of new chemical substance in China. It will be subordinated to this new regulation. The bottom tier is for technical standards. There will be technical methods, procedures, and specifications for environmental risk assessment, fleshed out accordingly. Of course, there are international conventions to follow as well. In this slide, I list the relevant authorities. In the draft regulation, MEE only outlines its own responsibilities. The Ministry of Ecology and Environment is responsible for organizing the environmental risk assessment, guiding, coordinating, and supervising the environmental risk control of chemical substances. While for other relevant ministries, for example, MIIT, MOC, GAC, SMR, and others, the details of their responsibilities are currently being developed. There are only very general descriptions in this draft regulation. This part will wait inter-ministerial deliberation and bargaining. As I mentioned, China's regulation is promulgated by State Council. Given the administrative level of this regulation, China's government is likely to allocate a large number of resources to improve inspection and ministerial cooperation. Let's move to the second part about environmental risk assessment and control. The regulation will operate using the existing chemical inventory, namely the current IECC, as a reference to judge new and existing chemicals and impose regulatory compliance obligations. We can see the current inventory is based on the 2013 version, and then some new chemical substances finished the current regular notification, and after 5 years were added into the inventory and become existing chemical. We heard about that the authority is considering reopening its inventory supplementation program. However, so far no official announcement has been made, and there's no definite information as to when the supplementation will start. The only certainty is that the scope will be the same as before, namely only the substances manufactured or imported into China before October the 15th of 2003 will be eligible. There were cases of stakeholders that fulfill supplementation criteria but missed the previous supplementation deadline. Here you can see the deadline is November the 2011. But frankly speaking, obtaining sufficient evidence to prove the circulation of your chemical in China's market before 2003 will still be a problem. In this regulation, annual reporting of existing substance is newly introduced. For new chemical, annual reporting has been implemented for years. So in this slide, we only talk about annual reporting of existing chemicals. Manufacturers, importers, downstream processors, and users must report to the MEE the name of substance, the uses, and the quantity in the last year. The proposed frequency of reporting and the companies needing to report are the subjects of heated debate. Industry has pointed out that the reporting annually will be burdensome, especially if downstream users and processors are also required to report. It will have an excessive impact on downstream links in the supply chain. Also, unnecessary duplication of data will be inevitable. The official intent is clear, since annual reporting will give the government a clear picture on the volume and uses of chemicals circulating in the China's market, and will allow the government to dynamically adjust regulatory and supervisory activities. Information about the exposure arising from downstream use is difficult to obtain. That's why regulators want to collect information from downstream users. Notably, there's no small volume exemption drafted for annual reporting. The industry expects the reporting frequency to be changed. For example, like the United States, the TSCA, every 4 years, and the threshold set on quantity. We hope it can be changed, like for example 1 ton. Also, some experts propose to report substances based on hazards, rather than to cover all existing chemicals. Annual reporting is considered most, since it will trigger company-specific compliance activities. So if you have any comments on it, you'd better submit them within 2 days. Okay, next slide. The MEE will organize chemical substance environmental risk screening and publish assessment plan to prioritize chemical substances classified as persistent, bioaccumulative, or which pose high risks to environmental and human health, or the substance with potential high environmental exposure risks. Unlike the mechanism adopted in the EU REACH, China MEE will take the responsibility to conduct the environmental risk assessment of priority substances. Industry will be required to report necessary data, including emission data, local environmental impact analysis, physical chemical properties, toxicology and ecotoxicology data. MEE can request the enterprises to conduct additional tests if the existing information is insufficient for risk assessment. So assessment work will be slow compared with its international counterparties, for example, Canada, the CEPA, American TSCA, Japan CSCL. I remember only 28 substances were assessed on the Japan CSCL from 2012 to 2018. China's system hopes to identify, screen, and assess the priority substances more quickly, given that China's current capacity lag behind its international counterparts. Focusing on a large number of substances would be impractical. So far, there's no idea about specific technical methods and the timelines of assessment. For environmental risk control, based on risk assessment, 3 key lists are introduced. Substances subject to priority control, the severely restricted substances, and prohibited substances. They will be screened out accordingly. In addition, the authority will directly include the substances managed under international conventions, including the Rotterdam Convention, Stockholm Convention, and the Minamata Convention on Mercury. The whole list haven't been published. However, we know that some existing lists will be incorporated into them, which we will talk about later. For substances subject to priority control, MEE will establish a public information platform. Enterprises that produce, process, use, or import such chemicals shall publish on the platform the name, the quantity, uses, and the discharge information in the previous year, as well as the waste disposal and the implementation of environmental risk control measures. Here, the risk control measures have been listed here. According to the regulation, one or more of the following measures should be adopted to prevent and reduce the environmental risks. The enterprises should communicate with the downstream users the control measures. Management of substances subject to priority control is not a brand new idea. Actually, a batch of substances has already been published in December 2017, which includes 22 substances. You can click here to access the lists. Here's the substances. The list also functions as a reference for the development of the list of toxic and hazardous air pollutants, water pollutants, or pollutants to soil, which should be managed according to corresponding pollution prevention law. The first batch of toxic and hazardous air pollutants has been published in last month. And for water pollutants, the first batch just finished public consultation and will be published soon. For substances severely restricted, China updated the list of severely restricted toxic chemicals in December 2017. The scope of severely restricted toxic chemicals is narrowed down greatly from the previous 162 types to only 10 types. The listed chemicals are based on and consistent with the international conventions. The list of substances severely restricted will be established based on the current list. The substances will be subject to import and export licensing, which is the same requirements as now. Before import and export, you need to obtain the clearance notification for environmental management on import and export of toxic chemicals from the MEE, and based on the HS code and this clearance notification, the customs will release the goods. For prohibited substances, currently no such list available. So the industry has advocated for the government to include an assessment of socio-economic impact before any restriction or prohibition measures are taken. The direct line of communication between the authority and industry should reduce the stress on individual companies. In addition, increasing transparency is also a major concern. Now we are on to the issue of new chemical management, which is quite a concern of you. Here is the legislative evolution of China's new chemical management. The current MEP Order 7, namely the measures for the environmental management of new chemical substances, will be a subordinate measure of the regulation. MEP Order 7 is currently under revision. The revision will be aligned with the provisions in this regulation. In March of 2016, China MEP notified WTO on the revised draft of the new chemical substance notification guidance, which is the most important supportive document to MEP Order 7. And in August of 2017, the revised data requirements and the exemption conditions in the guidance was published individually. However, the complete draft of the guidance will not go public until the official release of the revised measures. It is hard to say if the revised MEP Order 7 will be delayed. It may be issued before the regulation, as long as it is revised within the legal framework of the regulation. In this draft regulations, there are some changes compared to the current new chemical management system. The most important is the registration type. New chemicals manufactured or imported at or above 1 ton per year should be registered. It is the same requirement as now. A simple record keeping, or we call it a filing system, will be in place of the current simplified notification for new chemicals manufactured or imported at below 1 ton per year, for new polymers containing less than 2% new chemical monomer, or for PLC, and for new chemical substances manufactured or imported at below 10 tons per year for no more than 2 years, for product and process-oriented research and development. Notably, filing system will free up the technical evaluation committee experts from engaging in burdensome technical review work for countless simplified notifications. Relevant activities can be carried out directly after receiving the receipt. Compared with the current practice, it will be faster. In addition, we will see exemption for new substances used at below 100 kg per year for R&D and for reference standards. Namely, the current scientific research recording notification will see exemption directly. The industry welcomes such changes, of course. There are some other important changes for new chemical management. The first one Administrative fee. Yes, in this draft regulation, the authority drafted that there will be administrative fee paid to the authority, and currently it's free. The second one, in this regulation, the Article 22 indicates that the persistent bioaccumulative and toxic substances, namely the PBT substances, or substances have equivalent hazards, will not be approved and will be directly classified as prohibited substances. It is unknown if the screening criteria for listing a substance as prohibited will be based on uncontrollable risks or some other criteria. In addition, we think it's better to specify what is the equivalent hazard. The third one is about inclusion into IECSC. For adding registered new chemical into the existing chemical inventory, currently it needs 5 years from the first date of its manufacturing or import. However, as proposed in this regulation, the 5 years will count from the date of registration, namely the issuance of the certificate. But it seems not so reasonable. For example, we can take an extreme case, for example, where the company do not manufacture or import in 5 years. How can it be rational to include a new chemical as existing when it hasn't ever been actually circulated in China? The fourth is about the certificate. For the items specified on the registration certificate, currently both the certificate holder and the notifier should be put on the certificate. Domestic notifier is the holder of certificate. When the notifier is a foreign entity, the local representative agent based in China will be the certificate holder and will take all the responsibilities required as in the MEP Order 7, for example, updating new hazardous properties, if found any, submitting annual report, adding new risk control measures, and implementing such measures accordingly. However, the draft regulation only mentions the certificate holder. It may be because that the draft revision of China New Chemical Substance Notification Guidance in 2015 allows foreign notifiers to become the certificate holder. However, the responsibility of registration certificate holder must be assumed by foreign notifier and the local representative jointly. The only difference is the foreign notifier can actually own the certificate. The fifth, we'll talk about the environmental risk control measures. Yes, more risk control measures should be specified on the certificate, especially the limitation on emission quantity or emission concentration of new chemical substances. However, I think it is hard to determine it, which require further specifications. Okay, so the last point is about penalty. In this regulation, there are one chapter deals specifically with the legal liability of officials, experts for review work, the testing institutions, and enterprises. Here I will not give further elaboration. Just for example, enterprises will face penalties for breaches of new chemical management rules, which are up to 1 million yuan for failure to register a substance, and up to 2 million yuan if serious issues occur due to their illegal activities. It is much higher than the current level. This draft is only a MEE's draft. It is uncertain when this regulation will be finalized, which is not only at a preliminary development stage, only collecting feedbacks from industry. However, we can see the authority is determined to accelerate the legislative process. However, considering there are steps like public consultation, internal deliberation, interministerial bargaining, the state council will have its own draft version and will submit to the WTO. All these steps, we expect it to be a long time before the final promulgation. Here you can find more resources on ChemLinked.com, including the news and the English translation of the draft regulation. Chemical management in China continues to develop, and I hope my brief introduction on the new draft regulation has given you an idea about the future management plans and the potential impacts on the industry. The regulation is currently under public consultation, and the consultation period will end on February the 20th. Namely, you still have 2 days to comment. The comments you make will be crucial to future management of chemicals in China. Okay, a very short presentation. Thank you everyone for your attention.